Intellectual property rights. Under intellectual property law, owners are granted certain exclusive rights to a variety of intangible assets, such as musical, literary, and artistic work, discovery and inventions, words, phrases, symbols, and designs. Intellectual property rights are the rights given to the person over the creation of their minds. They usually give the creator an exclusive right over the use of his/her creation for a certain period of time. There was difference between intellectual property and industrial property. Today, the distinction between the two has almost disappeared. Most people use intellectual property as a catch-all term, including patent and other items that traditionally were considered industrial property. The term intellect property and intellectual property rights are sometimes used differently. Like, the term IP means the abstract product of the intellect property, and the term IPR means legal right covering IP. The rights of authors of literary and artistic work, such as books and other writings, musical compositions, paintings, sculptures, computer programs, and films, are protected by copyright for a minimum period of 50 years after the death of the author. Also protected through copyright and related, sometimes referred to as neighboring rights, are the rights of performance. Example, actors, singers, and musicians, producers of phonographs, and broadcasting organizations. The main social purpose of protection of copyright and related rights is to encourage and reward creative work. A copyright gives the creator of an original work exclusive rights to it, usually for a limited time. Copyright may apply to a wide range of creative, intellectual, or artistic forms or works. Copyright does not cover ideas and information themselves, only the form or manner in which they are expressed. Several exclusive rights typically attach to the holder of a copywriter, like to import or export the work, to sell or assign these rights to others, to transmit or display by radio or video, etc. The phrase exclusive right means that only the copyright holder is free to exercise those rights and others are prohibited from using the work without the holder's permission. Copyright is sometimes called a negative right as it serves to prohibit certain people from doing something they would otherwise be able to do rather than permitting people to do something they would otherwise be unable to do. Copyright is with the intention of enabling the creator of intellectual wealth to receive compensation for their work and be able to financially support them. Copyright encourages creative work with the moral basis of copyright law, that is, thou shalt not steal. A patent is a set of exclusive rights granted by sovereign state to an inventor or their assignee for a limited period of time, in exchange for the public disclosure of the invention. An invention is a solution to a specific technological problem and may be a product or a person. Patent are form of intellectual property. A trademark is often referred to as a brand or a brand name and is used by business as an identification mark to distinguish their goods or services from those of their competitors. A trademark is defined in the Trademark Act 2002 as any sign capable of being represented graphically and distinguishing the goods of one person from those of another, and can be a name, picture, signature, color, word, shape, sound, smell, or any combination of this so long as it is distinctive. If you register your brand name as a trademark, you will receive a statutory right to protection of that name throughout the whole country, regardless of your reputation. Trademarks are valuable business assets in that they can be sold or licensed. If a computer starts to use the same or a similar name, trademark registration gives the owner of the trademark a quicker, easier, and cheaper way to prevent that competitor from using that name than relying on the Fair Trade Act 1986 or an action in passing off. Broadly speaking, any confidential business information which provides an enterprise a competitive edge may be considered a trade secret. Trade secrets encompasses manufacturing or industrial secrets and commercial secrets. The subject matter of trade secret is usually defined in broad terms and includes sales methods, distribution methods, consumers profile, advertising strategies, lists of suppliers and clients, and manufacture processes. Trade secrets are protected without registration, that is, trade secrets are protected without any procedural formalities. A trade secret can be protected for an unlimited period of time. Properties rights are the means of protecting and rewarding innovation. Its main objective is to reward and to protect the innovation.